Now, the right to speedy trial has been defined by state law and federal statute over the years under our systems of dual sovereignty. And so there's three areas of law where the right to speedy trial is guaranteed. The United States Constitution, the Sixth Amendment, what I was just talking about, Article 1 of the Texas Constitution, which is where our Bill of Rights are, and then under our state statutory law, there is also preserved a right to speedy trial. And so how is that determined? If there is a delay, well, first there's going to be an analysis whether the delay was reasonable, and second, if it was unreasonable, what are the reasons behind that delay? Are those due to agreed resets of trial proceedings or pretrial matters to have additional time to work out plea bargain arrangements or plea bargain discussions or dig through discovery, or because defense attorney or state's prosecuting attorney's office had multiple trials on their schedule, etc.? And then lastly, whether or not that criminal defendant has asserted his speedy trial in a timely manner, gotten a ruling, and had it denied. And while there is a very important case and some state and federal law that says delays of more than 8 months can be unreasonable, all of these other factors are going to weigh into that. And the critical thing is it's got to prejudice the defendant. And the only place that it can prejudice a defendant, really the winning argument there, if it's going to carry weight, it's got to have caused some inability by that defendant to now secure the subpoenas for the witnesses that defendant needs to support the defense. So, or something along those lines. In other words, if the delay is excusable, but it has now, because of the delay, because of that delay, has caused an inability in that defendant to now subpoena a necessary witness for the trial on the merits or something to that effect, evidence is gone, memories have faded, then that could give rise to a viable complaint for speedy delay. But under our system of justice, cases move along fairly quickly, and because it's really an analysis of this entire set of facts, not just look at a calendar. If it's 8 to 10 months out, well, you've got a speedy trial violation and case is over in favor of defendant. That's not how it's going to work. It's got to be something that caused a prejudice that the defendant can't recover from. Anyway, in closing, I hope this has been somewhat of a helpful explanation of the rights that are subsumed within our Sixth Amendment, that it really encompasses a great deal of rights, not just the right to a speedy trial. And then, of course, what does a speedy trial mean and how that is critical, not only to think about in any situation regarding an allegation of something against the peace and dignity of the state of Texas or the United States of America, in other words, a criminal offense, but also those things like right to confrontation, right to jury trial, the things that are critical in any scenario where your rights, property rights, family rights, liberty rights are being weighed in our system of justice. Anyway, have a wonderful day.